Seated. Wrote it.
Thank you, Judge. Before you is case number 26, CR 886, captioned State of Ohio versus Tierra M. McCrae. Judge, on July 27th of 2026, the state filed an information. Contained in the information is one count, is the charge of failure to comply with an order or signal of a police officer, a felony of the third degree, in violation of ORC 2921.331B. The defendant, is the state's understanding, wishes to waive her right to have her case proceed to the grand jury and plead guilty to that charge outlined in the information. She is present today in court with counsel Mr. Watson, and we are here for that purpose, Your Honor. Should that plea be forthcoming, it's the state's further understanding the defense intends to ask for a pre-sentence investigation and possibly a drug and alcohol evaluation.
All right.
For the record, Judge, I'm handing you the written waiver of indictment. The defendant has signed it with Mr. Watson as well as myself on behalf of the state of Ohio.
All right, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Watson some more, let me know and I'll give you more time. Do you understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have a constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to be given a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No.
Do you still want to plead guilty to this charge?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
Failure to comply with the order or signal of a police officer is a felony 3. It carries a 60-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes.
Do you understand that with this charge there's a mandatory driver's license suspension of at least 3 years up to your lifetime?
Yes.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate any conditions, the parole authority can send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If the violation is a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
The maximum prison term for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control, but if you violate the conditions, I could send you to prison for 60 months. Do you understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk to Mr. Watson before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he's given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
No.
All right, Ms. Narode, if the case went to trial, what would the evidence show?
Your Honor, for the state proceeded to trial in this matter, the state would have brought forth the following facts, and that was this: that on or about June 22nd of 2026, as part of a course of criminal conduct in which one of the offenses or any element of the offenses occurred in Lake County, Ohio, that the defendant did operate a motor vehicle after receiving a visible and audible signal from a police officer to stop, and the operation of that vehicle caused a substantial risk of serious physical harm to persons or property based on the evaluation of the factors in 2921-331C5. And that were these, Judge, that the pursuit began in Ashtabula County in the area of Austinburg Road as a result of a Ashtabula, or a trooper from the Ashtabula post, or the Warren post, observing the defendant operating the vehicle and in excess of the speed limit on, I think it was Austinburg Road, 60 miles in a 45-mile-per-hour zone. As a result of those observations, he got behind the vehicle, activated his lights and sirens. The defendant continued in the vehicle and turned onto State Route 45 and began traveling on that interstate all the way into Lake County. The pursuit lasted approximately 15 minutes and 21 miles. During the course of the pursuit, speeds of 100 and 110 were reached. Multiple vehicles were put at risk. They had to pull over. The defendant operated the vehicle on the right side of the berm, going around semis and vehicles, causing them to come to abrupt stops. And eventually, as a result of troopers from the Chardon post who provided mutual aid to the original Ashtabula troopers, deployed stop sticks to stop the vehicle, as the defendant never voluntarily brought the vehicle to a stop. The vehicle veered off the right side of the road, and the defendant got out of the vehicle and ran into the woods at that time. So the duration of the pursuit, as I said, was 15 minutes. It was approximately 21 miles. And there were speeds in excess of 100 miles an hour. Multiple agencies were involved, and she committed numerous moving violations during the course of it.
All right, Mr. Watson, anything to add to those facts?
No, Your Honor.
Ms. McCrae, did you hear what Ms. Naroda said, that the facts would show if the case went to trial?
Yes.
And are those facts true?
I told you he's not going to take your plea. So it's up to you. Well, we'll say it at sentencing. I told you that.
Yeah.
What is your plea then to failure to comply with the order or signal of a police officer, a felony 3?
I'm guilty.
Ms. Watson.
Alright, so this is the same paperwork that we just went over. So you are sentencing these days. You got this mandatory time. You are allowed for judicial release. So I need you to sign right there.
For the record, Judge, I'm handing you the written plea of guilty. It has been signed by the defendant, witnessed by her attorney, Mr. Watson, as well as myself on behalf of the state.
Ms. McCray, is this your signature on the written plea of guilty?
Yes.
Did you sign?
Evaluation, although I'm not opposed to that, there is a bit of a history, and there may have been drugs involved in this case. I was going to ask for a drug and alcohol assessment.
That'll include as part of the psychological.
All right, thank you, Your Honor.
Judge, I might have to change the bond order that I submitted.
What did you submit?
She just
Current
said
bond.
JD for bond.
I put 100,000 cash in. If you cross it off.
I don't even have it. So,
I'm sorry, I gave it to Mr. Gonzalez.
so he kept it from me. That's what he does. He keeps things from me.
All right.
Now listen, I'm going to see you. I have no court tomorrow. It's either tomorrow or Monday, okay?